Well, hello everyone. This is Jacob Stein, and we are ready to begin our webinar on copyright infringement and asset protection. So our speakers today will be first my good friend Scott Lesowitz. Scott is a graduate of Harvard Law School, and he is just a star litigator here in Los Angeles. Scott's practice focuses on litigating IP cases, in trademark infringement cases and the like, and he also has a large FTC defense practice. So Scott will start off today's presentation, and Scott, whenever you're ready, go ahead and share your screen, and then he and I will kind of go back and forth, and I believe everyone has the bullet points for the presentation. And for those of you who do not know me, I am Jacob Stein. If you do have questions, you do have the ability to ask us questions through the Q&A panel in Zoom platform. You're all also welcome to email either myself or Scott with any specific questions you have. Today, during the presentation, we will only answer questions about the law. We're not going to answer kind of very fact-specific questions that you may have. For those, please shoot us emails. So Scott, with that, please take it away.
Okay, thank you, Jacob. So today we're talking about copyright infringement and asset protection in relation to copyright infringement. I will be focusing first on the copyright infringement aspect of it. One thing that I think is important to address is why does this matter? Why does this matter for an attorney? And what's important is that in the copyright context, there's a dual issue here. One is that it is difficult to, oftentimes it's difficult to know what copyright infringement is, whether something infringes or not. And there's also the issue that the damages can be fairly draconian. And so you have to navigate waters where it's difficult to know if your client is or will be liable for something, but if he is liable, if he or she is liable, the consequences can be fairly severe. So with that, we start at the beginning. So what does it mean to receive a copyright, to have copyrights? I'll try to move fairly quickly through these parts. I know a lot of you, this will be a review. So copyright extends to original works of authorship fixed in a tangible medium of expression. Basically, this means that anything somebody writes, anything that someone records, anything someone creates, it could be a sculpture, it could be a physical design, can be copyrightable. You can be it's very broad. It's very easy to meet the fixation requirement. Doodling on a napkin can be sufficient. You can dictate into a microphone recorder, although I assume that people don't do that anymore, and or just record yourself singing on a cell phone. So the important thing about copyright is that no artistic merit is required. This means that essentially any type of expression that has a degree of creativity can be copyrighted. So basically, it's very broad, and it's unlikely that you're going to find something that isn't just, it's not artistic enough or not whimsical enough. The point is just that it's a new thing, somebody else hasn't created it before you, and it meets a fairly low bar of originality. Another thing is important is that copyright does not need to be registered. There's no requirement to get your copyrights to register it. And that said, as we'll discuss more, it's very important to register copyrights as soon as possible if you are someone, or your client is someone who has intellectual property and things that might be protected by copyright. Moving on, so we're talking about the breadth of copyright. One thing is that a copyright will almost rarely reach every single aspect of a work. So for instance, if you write a story, if your client writes a book, for instance, not every sentence will be copyrighted. There'll be, themes, for instance, ideas are usually not copyrightable. The ideas never, and the themes usually not. Plots, characters that are fairly stock will not be protected. But whatever is independently created is new and meets that minimal bar will be protective. One thing that is, I'll get back to this quite a bit during the presentation, is that protecting copyright infringement on the internet and websites. If you go on the internet, or if your client goes on the internet and downloads a picture and sticks it on her or his website, that is very risky. So even a photograph of someone walks outside, takes a photograph of a stop sign, it may receive copyright protection. Even just the angle in which it's shot, the position, the lighting, even those minor things might be enough to get copyright protection. I had a case where it was an attorney called me up who was being sued for copyright infringement because he was a bankruptcy attorney and he put up a stock image of money. That's all it was a pile of money that somebody took a picture of, and he was being sued for copyright protection, copyright infringement. Obviously, there's a degree of irony there that he was an attorney, but it shows how careful ones must be, and especially because, as we'll talk about more, there's a problem with copyright trolls, people who essentially sue on their to protect their copyrights for a living and probably make more money suing than they do off the actual material. So one of the big Supreme Court case, it's cited here in my slide, Feist Publications versus Rural Telephone Service. That is the quintessential case talking about the creativity bar, and especially with facts and function intertwining with copyright. So facts are, you don't create facts. The author of a work doesn't invent the facts. She doesn't invent the functional aspects. Those are not copyrightable. Facts are not copyrightable because it's not independently created, and then things that are functional are not copyrightable because there's an exception for that. That something is inherently meant for a purpose other than expression, it's usually not copyrighted. And then one of the big things is that ideas are not copyrighted. So in Feist, the plaintiff had created a phone book, and the plaintiff argued that it should be protected, partly because the listings, it took a lot of effort and expense to compile the information for the listing. They then created a book and laid out all the listings. And the Supreme Court said that while the standard for creativity is extremely low, that was their language, extremely low, that because the information listings is just an idea, it's not copyrightable, and they just laid it out alphabetically, and because of that there was no creativity. However, the court conceded that if there was an original method of presentation of the facts, then it would maybe be protected. And so, for instance, books of history usually receive copyright protection because even though the ideas themselves, the history, is not protected, there's many ways to explain what happened, and so that element would receive protection. So moving on, so works for hire. So this is getting more into the meat of things. An employer owns any material, the copyright to any material an employee creates within the scope of the employee's employment. This can be more difficult for employers than they can initially think. One issue is, besides just what is the scope of employment, is the issue of independent contractors. Independent contractors, by default, what they create is not the ownership remains with the independent contractor. One of the big lessons here is to enter into an agreement. Any employee or independent contractor that might be working on something or doing something that would accrue copyright protection, you want an agreement, you want something in writing, because then once again, this is a murky area of law, and what might happen is that the plaintiff hires somebody to make work, and then it turns out that the plaintiff only owns a non-exclusive license, meaning that the plaintiff can use that one copy that was created for the employer, or within a number of copies, like for instance a computer program, maybe they get a license to enough that would foreseeably fill the needs of their employees at the time, but then that's it. They can't copy it, they can't distribute it, and even their use of it might be very limited. Now moving on, so with that established, elements of copyright infringement. The two elements are the plaintiff owns a valid copyright and the copy of protected elements of the copyrighted material. Copying usually does not have to be exact. If the copying is exact, there likely will be infringement, even if it's a very low protected class of copyright protection. But usually you're going to be dealing with cases, at least if it's not a slam dunk case, where there's substantial similarity. And in those cases, the question is there substantial similarity between the two works at issue? Now the question though is, what is substantially similar? And the majority rule is that you go to the original work, you go to the second work, and you look at what elements that are actually copyrighted, what material that's actually copyrightable of the first work did the second work either copy or employ and or appropriate. And then you look at just those elements, the protected elements, and the court asks if they're substantially similar. The problem is, if you live in Ninth Circuit land or practice in Ninth Circuit land, Ninth Circuit has a weird minority test where it looks both at the similarity of the copyrighted portions, but it also looks at the bigger picture, the subjective impression of the two works. The problem with that is that it might create a situation where the finder of fact is looking at the works as a whole, which is usually not appropriate, because the question is the portions that are similar. You can't infringe the elements of someone's copyright of material that's not copyrighted. If someone writes a new version of Hamlet, anything in the underlying work by Shakespeare, the words, the ideas, the expression, that's Shakespeare's, that the new author does not own. And he doesn't, because he made a new version of Hamlet, he doesn't own the old version of Hamlet. So the Ninth Circuit's test, which looks also at the subjective whole, is often criticized. It's not usually followed in other circuits. And even in the Ninth Circuit, the courts are fairly inconsistent and are in a way shy away from their own precedent. And this also, once again, gets into how difficult it is to deal with copyright, because oftentimes the cases are close calls. It's hard to know where the courts are going to end up. And then, well, I said before that a copyright, to accrue copyright protection, does not require registration. To sue on a copyright for infringement does require either registration or that you be in the process of registering. But the registration can be done after the lawsuit, or after the infringement occurred the day before the lawsuit's filed, which actually is not that uncommon. I've seen plenty of cases where the person started registering the copyright a few days before the lawsuit. And so even though the copyright will not be adjudicated until by the Copyright Office until the after the complaint is after the complaint is filed, that does not matter. And interestingly enough, even if the copyright registration is denied, the plaintiff can still sue on it. It's the registration process going through that is what matters. So now we get into just a very brief overview of what a copyright owner has the exclusive rights to do. And they're broad. It's to obviously reproduce the work, copy the work, distribute copies of the work, perform the work publicly, and then it's important that these things are fairly broad. So for instance, displaying the work includes just signals that the viewer picks up. It could even be radio waves, displaying something via radio waves. So once again, these things are broad. If you just look at the statute, in reality, the law of the jungle is that it's broader than you would think or assume. So moving on then to the next slide, to digital copying. This is an area where it's close to my heart. I do a lot of internet and digital and computer related copyright issues and infringement cases. I've had a lot of clients who distribute applications online, for instance, and companies have infringed them either by making very similar programs or just basically just downright stealing it. But as we get more into this, there's the issue of what you do which is often the case when it's a foreign entity or people that are doing the infringing. So in the digital context, basically doing anything with copyrighted material is considered a copyright violation, essentially. When you upload, the defendant uploads something, that implements the copyright protections. When there's downloading, that is considered an act of copying, displaying, etc. One of the protected rights is always at issue when there's uploading, downloading, transfers of data, use of servers is a big one. Courts are they look at that a lot. They put a lot of weight into where a server is, especially for jurisdictional purposes and for determining where a copyright infringement took place. So looking at the three cases that I cite here in my slide, in the Perfect 10 case, the Ninth Circuit found that just transferring a computer program from a disk into a computer itself is an act of infringement. And so it would seem clear that if you put a DVD into your computer and download a program onto that DVD, that would be an act of copying. But even if you own something outright and the original DVD was made lawfully, just installing it on your own computer can be a copyright violation. If it's not, the license doesn't fill it. Because one issue is that almost always when companies sell computer programs nowadays, they're in the fine print in the documentation is a stipulation that the user actually doesn't own the program. He just owns the right to use the program, a non-exclusive license. And so the license oftentimes is very narrow. And so the number of computers, even if it's the same one person that he or she can use the program on, is oftentimes narrow. Then the My Systems case, another Ninth Circuit case, which is more controversial. Perfect 10 is not controversial. My Systems is, and that was just moving a computer program to a computer's RAM can be copyright infringement. So while the issue is not settled, yes, running a program basically can in and of itself be infringement, because a computer always moves the data from permanent memory to its short-term memory. It's random access memory, RAM. And so it's, once again, it's almost unbelievably broad how much infringement there can be, how many infringing acts, the scope of it in the digital context. A recent case, I guess not so recent anymore, the Capitol Records case out of the Southern District of New York. In that case, there was a system where the service was designed to allow people who own digital copy, MP3 or digital copy of a song to sell it to somebody else, and it was in a way like a traditional CD. There's the first sale rule. So if you own a book or a CD, you can sell your hard book or hard CD to somebody else without the permission of the copyright owner, because you buy that copy and you can sell that copy. You can't make additional copies and sell those, but you can sell your one copy. So using those principles, the defendant created a service where the plaintiff would upload the song onto the service, and when the upload occurred, the user would immediately lose the file. The file would be deleted from the user's computer, and the court said, no, there's still infringement here, because basically every step involves making a copy. So you make a copy on the software, the Redigi software or servers, that's making a copy. Then when Redigi sells it. So it's not just the issue of selling the copy, it's the issue of making a copy, the act of copying in the more figurative sense. So coming back to another idea we had, just because your client buys a license to use something, the person needs to be very careful about the license requirements. For instance, the number of computers that a piece of software can be installed on. I've seen plenty of cases where the plaintiff is a software maker who sues because companies are making too many copies. And once again, the remedies are broad, and so it's worth them suing. And I had a case recently, for instance, where someone actually went and bought a piece of clip art, put it on his website, and that was an act of infringement because in the license fine print, he had to give attribution, and he did not give the attribution. So once again, buyer beware, especially on the internet, buyer beware. Now, one of the most common defenses for copyright infringement is fair use. Fair use is not infringing. I'm sorry, we're on the fair use slide right now, which is the 9th slide. The fair use protects things like the statute actually defines them: criticism, comment, news reporting, teaching, scholarship, and research. That said, it's a very hard test to apply and to predict what a court's going to do. Once again, this is why it's important to think thoroughly about what Jacob does, and that is asset protection and thinking through what happens in case of being sued and there is a judgment, because the judgments can be fairly draconian, and it's hard sometimes to know, will I or will I not be found to be an infringer, especially because infringement does not require any type of mens rea, any type of intent, just the act of copying. Even if you don't intend to infringe. And in a famous case involving George Harrison of the Beatles, he had a song, My Sweet Lord, which he sounded too much like it incorporated too many of the elements of an earlier song. And even though George Harrison didn't consciously think to make a copy of that song, he subliminally knew that song. He knew the song and subliminally just made a song that was too similar, and that was enough for infringement. Actually, probably one of the most famous cases of copyright infringement in the music context. So in the fair use, there's 4 factors: whether it's a commercial use or it's a non-commercial use, the nature of the copyrighted work, how much is copied. Once again, less copying a smaller portion is more likely to make fair use, and the effect on the potential market values is important. If it's a use that is not going to affect the business of the plaintiff, it's not going to be more likely to be fair use. Now, one thing that's important here is that just because in the context of parody, especially in criticism, just because the nature of the commentary or the parody hurts the value because it diminishes the original in the eyes of the public, that is not considered a detrimental effect on the market value. Because obviously, that's designed. A parody is designed to, especially criticism, is designed to harm the work at issue. So moving on to the next slide, the danger of relying on fair use. It's once again, it's difficult to know. And one of the big cases, Supreme Court cases, was the Harper and Row case. And there, Gerald Ford, ex-president at that time, Ford's autobiography was being released, and a magazine received an early copy. Wasn't supposed to. Somebody did it without permission, who was on the inside, and they then took about 1 page total of written words and published them in a news story. And the court said there was no fair use. It was a commercial nature, and even though the amount of copying was small, it was verbatim, and it was the most important parts of the work. It was actually mainly about his decision to pardon ex-President Nixon. Once again, so where this tends to be most applicable is when your client is using a image, a work, and is doing some type of commentary or discussion of the picture. It gets into murky waters, depends how much commentary there is, how much the picture or the audio or written word is, how important it is to the commentary, and it's a murky test. One example I have is that somebody, I'm not even remembering his name, was such a minor celebrity, had been on LA Law years before. The author put a picture of him up there because it was talking about that person. And while we didn't get to a trial, very likely that was enough that was infringement. It wasn't fair use because just because it's a news story that's talking about the person, it doesn't mean you get to use a photograph of that person for free unless you're. But then there's also a case out of appellate case where it involved out of Puerto Rico that involved a newspaper using for free a photograph of a celebrity and then commenting on the photo. But the photo really wasn't commenting on the photo in a criticism or critique of the artistry. It was just a picture of the person who was the Miss America of Puerto Rico, and she was doing something that was fairly scandalous in the photograph, and so it criticized her, what she was doing in the photograph, and that was fair use. Okay, so this kind of gets more in the heart of things, remedies. So and this gets into, especially as you get into damages, it's important to remember the importance of registration. So first, we're going to talk about just general damages that are available, whether or not there was registration at the time of the infringement. And so a successful plaintiff is entitled to the damages of how much money was lost from sales, how much also was lost from licensing fees. That's a common way to measure the value, is how much licensing fees were lost, including to the defendant, how much the defendant would have paid at market value to license the material. And oftentimes that's what the damages are. And also very important is the successful plaintiff is entitled to disgorgement of profits. That's important because oftentimes it's difficult to say that the plaintiff lost money because of what the defendant did, but it's easy to prove that the defendant made money. But do remember there's no double counting, so if the plaintiff loses $1,000 in sales and the defendant then gets that $1,000, the damages are $1,000, not $2,000. One important thing, although it gets murky, and once again, courts are not the best at this, is that the damages should only relate to the use of copyrighted material. So if, say for instance, a movie uses 5 minutes of if 5 minutes of a 90-minute movie is infringing, the damages should not be 100% of the profits of the movie. It should just look at the increased revenues because of the that 5 minutes of footage. Again, if another example, if a CD, one song on a CD that infringes a copyright, the plaintiff shouldn't be able to get all the money from all the sales of the CD. It should somehow be apportioned to determine the amount of sales based off that that one song. So, and then another thing to remember is that punitive damages can be awarded. Traditional standards apply, and sometimes it's injunction actually that really can knock a defendant down, because even if the amount of money is at stake is hard to prove, if the person is not allowed to even use a underlying work, it can be devastating and force the defendant to pay a lot of money to the plaintiff. So for instance, let's say there's a movie that has an underlying soundtrack that happens frequently during the movie, and that's infringing, but the dialogue's not infringing, the imagery is not infringing, so damages might be fairly small. The plaintiff might be entitled to injunction preventing the movie from being displayed or distributed, the entire movie, because it's impossible to separate the display of the non-infringing parts of the movie and the infringing parts. So it's going to get more into statutory damages now. That's the prevailing plaintiff has the can elect to receive statutory damages if and only if at the time of infringement the material was registered. If you register within 3 months of publication, the copyright date, registration date relates back to the date of publication. If and only if the plaintiff meets those requirements, he or she can receive statutory damages. It's election, you can't receive actual damages and statutory damages. Statutory damages are, depending on the factors and the context, a minimum of $750 up to $150,000 per work that's infringed. One thing is that the $150,000 is a lot lower than trademark statutory damages can be, where I believe they go up to $2 million per work infringed. But there's an interesting thing happens here because, for instance, I represented recently a computer game maker, and a defendant ripped off that program and then put it on the internet and made a lot of money. But the problem was the money was located in China, and it was very difficult to collect on any of it and of those sales. But so we would have liked to do statutory damages, but the problem is you capped $150,000 even though an entire work was infringed. Whereas if you have somebody who distributes 50, a mom in Iowa uploads 50 songs, MP3 files onto the internet, the plaintiff's entitled to up to $150,000 times 50. So you get this kind of unfair result, I believe, and you're right to a jury to determine the fees. One really big issue for copyright cases in general is the award of attorney's fees. Attorney's fees might be awarded in any case. It's to the successful party. There depends on the litigation position, the egregiousness of the defendant's acts, interestingly enough, the plaintiff brings a frivolous suit. The defendant could actually get attorney's fees. Also, registration not required. This is a huge incentive for copyright trolls to bring lawsuits because, number one, they get statutory damages. So if 25 photographs are taken, they're going to get a minimum of around $20,000. But then also the attorney's fees very well might be covered, and it really creates a problem for clients because of being in a situation where even though the copying was fairly minuscule, and even cases where the plaintiff's claims might be weak, to go down a road where you might have to pay the plaintiff's attorney's fees, which obviously, in a major litigation could be hundreds of thousands of dollars, creates an incentive to settle for fairly cheap. And it's fairly common that defendants are hit with lawsuits and then get a demand for $15,000. Getting into now the action of employees. So the employer is generally responsible for the infringement of an employee when the acts are in the scope of employment. So there's two types of vicarious liability, though, in general. One is basically the contributory and the vicarious. The employee context is the vicarious, where the employer is receiving a financial benefit, direct financial benefit, and has the right to supervise the employee. And the other one is contributory infringement. That's usually a case where somebody is getting a benefit like through a supplier or seller and has some type of directing somehow the infringement, or no, he's benefiting from it. The interesting thing here for asset protection is designing companies and their structures when they are creating content that is likely infringing. There was a 10th Circuit case, I'm here on the liability for the actions of employees slide, and they found that there was a internet news publication, basically just a rag, did celebrity gossip, and they were paying independent contractors to write content for the website, which was uploaded, and people were paid for the number of views and the content, the length of the content, and so they were paid largely based off the success of the content. And the court said, they're independent contractors, you're not liable. You didn't tell them to infringe, and they were independent contractors. The people worked on their own. Much criticized opinion. I personally don't like it, but it creates a situation where you don't necessarily want to use in-house people. Especially if, for instance, if a company is going to design a website, make a website, don't do it with in-house people. Hire outside people to do it, because there's less likely to be liability. Now, moving on to foreign issues, I do a lot of practice in this area, and the first jurisdiction, the question is, oftentimes infringers are abroad, and so the question is, can the court in the United States exercise jurisdiction? For instance, if let's say it's a Chinese or Russian or Indian or Venezuelan infringer, good luck going to the court in that country and enforcing the copyright. So oftentimes people want to enforce in the American court, want to bring suit in the American court. And so the question is, what constitutes, what's can be done for jurisdiction? And the big question is just the standard jurisdiction test you learned in law school, whether there was purposeful direction at the form. And so one interesting issue is just using Google or Apple enough to find jurisdiction, and the courts have pretty much unanimously agreed, no, just because you use Google or Facebook or whomever as using those services in aid of your business, it's not enough. But one case of mine, the Goes case, the issue there was a foreign defendant was from China, was uploading the application of my Swedish clients' video games onto the Apple App Store. And the court found jurisdiction there. And the big thing there was that the Chinese defendant was uploading the games onto the App Store, which creates a copy in California on the California servers. Once again, the courts are obsessed with this idea that the servers are located in the form. And but in order to do that, the infringer had to select which countries to distribute the game in, and one of those is the United States. That was enough to find jurisdiction. Please remember, if you're bringing these cases, 4K2, FRCP 4K2 allows jurisdiction if there's enough contacts with the defendant, with the United States as a whole, but not any single state. That was the crucial way we won in Goes, because there the defendant was reaching out to the United States to distribute in the United States, but didn't do it to any state. They didn't select which states they wanted to sell the program. I'm trying to move on quickly so Jacob can speak. Extraterritorial liability and damages. Something that purely happens abroad, there's no infringement. Has to be some act in the United States, one full act in the United States. Uploading files from abroad is usually actionable. The cases there are, for instance, when someone abroad uploads a video onto YouTube where viewers in the United States can watch it. That is, there's a United States infringement there. One of the cases I like to cite when I'm trying to argue for infringement is the CONUS Communications case, and there it was a perfectly fine use of the copyright laws where the Canadian broadcaster was broadcasting to people in Canada, but because there was spillover in the United States, there was infringement. And then we then look at the Allercom, which is the quintessential Ninth Circuit case. When the broadcast was from the United States to Canada, there was no infringement because the infringing act was considered to be the copying the display in the viewer's place of residence viewing, and so there it was Canada, whereas in the CONUS case it was the United States. Getting these really fine distinctions that the courts really care about. And then extraterritorial damages. If a infringing act, let's say you get through liability, the question is foreign sales. Oftentimes those are collectible. The big case on that is the Sheldon versus Metro Goldwyn case. There's a learned hand case, and the negatives of a movie were shipped abroad and then displayed abroad. And the court said, well, because the act of copying in the United States, of copying the negatives was an act of infringement, you then get the sales in abroad. Once again, the amount of damages, scope of damages can be broad. Knowing if there's infringement, though, is difficult. Knowing what's collectible is difficult. And so oftentimes the best thing to do is to settle and be prepared for liability. With that, I pass it on to Jacob.
Well, Scott, thank you so much. It was a wonderful presentation. I myself have learned quite a bit, and I appreciate the slides. They have a lot of good information on them. And Scott, we'll stay on the call, folks, so that if you do have questions towards the end of the presentation that you'd like Scott to answer live, he'll be available to do so. For now, a couple quick housekeeping notes, some questions that came up from some of the participants. Can you get a copy of the slides? Yes, everyone can get and will get a copy of the slides. And when we email you the CLE certificates within the next couple of days, we will also email you copies of the slides as well. If you don't get it in the next couple of days, then please feel free to reach out to Natasha, to Alliance Marketing Director. She's the one you got the registration information from, and she will get it to you. All right, so in the 15 minutes we have left, and by the way, you do have to stay on till the end of the presentation to get the CLE certificates, and we do have to monitor that. So if you stay through the end of the presentation, you get the CLE. This presentation does get recorded, so you can get the entire presentation, including watching the slides advanced, just like you're doing right now. You can get it all later. We make these presentations available on our website, on Alliance website, and also on Alliance YouTube channel. So, and here you have the information for Alliance website. So with that, in the 15 minutes we have remaining, let's talk a bit about asset protection for intellectual property, and also asset protection in the context of infringement of various, let's say, copyright rights or other intellectual property rights. So we had a couple of cases recently. One was a fairly well-known author who was facing really a case of plagiarism, right? But it was technically copyright infringement, where he apparently stole some small parts of someone else's work. published work. And then we had another case. This was a fairly significant client who operated adult online, adult websites with lots of content, and they got hit with a copyright infringement lawsuit. Apparently, they were distributing content that they did not have the rights to, and they ended up losing a $15 million judgment. Became obviously uninsurable for copyright infringements. So how does asset protection play into all of those cases? And there are really kind of two components to this. One is, what do we do when a copyright infringement has taken place, or any sort of other IP infringement has taken place, and there is a lawsuit. It may be a lawsuit against the legal entity. It may be a lawsuit against an individual. So once there is a lawsuit, is there something we can do? What is it that we need to do? And then the other question, the other issue to address is there some prospective planning we can do? Like, how should we structure our affairs in such a way so as to minimize damage from these types of lawsuits? So let's run through that. Run through that real quick. So when we're talking about asset protection, our goal primarily is to make assets unreachable by creditor claims, right? And if we cannot make them unreachable, then the kind of runner-up goal would be to make assets difficult and expensive to get it, to change the negotiating ability of our client, to put the client into better negotiating position and settle with the plaintiff. So let's talk first about the case where the infringing act has taken place. Our client has gotten sued, like the author we represented recently or the adult content company. What do we do in a case like this when there is already a lawsuit? And let's say we do expect that a large judgment will be entered against our client. Well, the first question to consider is whether the lawsuit will be against the individual or the lawsuit will be against the legal entity. If the lawsuit is against the legal entity, does the legal entity have assets that the plaintiff will be able to go after? What sort of assets does this entity have, and what can we do to get those assets out of that entity into some other entity or into some sort of an asset protection structure? So a very specific example. Our online content client, adult content client, gets hit with a lawsuit and is the corporate entity being sued. The plaintiff is asking for a ton of money. And if they get a judgment against the corporation, what are the assets of this corporation? Well, this corporation happens to own very high traffic websites, domain names that have a ton of value because of the amount of traffic that they receive. This corporation owns a lot of content, has lots of relationships with affiliates, lots of revenue sources, and the like. So lots of valuable assets, both assets that are sort of current assets and revenue streams, future assets. So how do we protect those? Not easily, I should say, because with something like domain name ownership or content of a website, that's all discoverable, right? At the end of the day, the plaintiff can go to ICANN and either just look it up or maybe through a subpoena discover who owns the domain names, figure out which domain names a particular person, including a legal entity, owns, and then once they get a judgment, get the domain names turned over to them and become the owner of the domain names. Likewise, the code that our client owns, right, the website itself, the code, the content of the website, that's an asset. It's personal property, and like any other personal property, it can get turned over to the plaintiff. So in cases like this, we want to try to move the domain names. We want to try to move the content, whatever trademarks this business may have, because this business also may have its own trademarks, which have value, out of that corporation that is being sued. That part is not difficult, right? Moving assets out of a legal entity is not difficult. What may be difficult is how do we do it so that there are no significant tax consequences? And how do we do it in such a way so that successor liability does not attach? Right? Because if we simply strip out all of the assets from the existing business and just incorporate a new business, a new legal entity, the plaintiff will argue that the new legal entity should have successor liability for the debts of the old business. So with successor liability, to defeat a possible successor liability argument, we need to show that there is some substantive distinction between the two businesses. The most important inquiry being, is the ownership the same? And if we can show that the ownership is different, that goes a long ways to avoiding successor liability. But courts will also look at, what is the nature of the old business and the new business? Do the businesses have the same employees, same address, same phone numbers, so on and so forth. So we try to introduce as many distinctions as we can, and maybe we cannot make it impossible for the plaintiff to attach successor liability, but if we make it difficult enough and expensive enough, we will change their economic analysis of the case and bring them to the negotiating table. This sort of dovetails a bit into prospective planning. When clients like this come to us and they're concerned about possible claims and lawsuits, one of the things we will tell them is, let's separate out the assets from the liabilities. So for example, if you do have a business like this that publishes content online and they are worried about some possible infringements, which may be intentional or unintentional, what can we do? Well, perhaps we can try to move out as many of the assets out of the entity that will get hit with the infringement lawsuit. So we can have a third person and some third parties, another entity own the domain names, right? And then license the use or lease the use of the domain names to the operating entity. We can have a standalone entity own the intellectual property of our client, like trademarks, and license those to our client. Even the content itself, even if it starts off being owned by our client or his existing business entity, we can move ownership elsewhere and then license it back to the operating entity. So at the end of the day, we want to create a structure, and I think somewhere here I had a slide on this right here. We want to create a structure. The slide was for a manufacturing corporation, but it's exactly the same logic, where you have one entity here, the corporation, that's the operating entity that is exposed to risk, that is exposed to lawsuits, and you have a completely different entity here, an LLC, that owns the underlying assets, right? So you try to make it as difficult as possible for the plaintiff to connect their lawsuit to something of value, to the assets of the entity. In these cases, there would often be corporate entities being sued, and these corporate entities either have assets, and maybe then we can somehow protect them, or they have no assets. And in either case, what the plaintiff will likely do next is try to go after the individual assets of the persons behind the entity, of the personal assets, of the individuals behind the entity. So, our client who owns the corporation, he is worried that the plaintiff will argue alter ego, pierce the corporate veil, and go after his personal assets, right? Go after his home and life savings and so on and so forth. So what can we do to mitigate that? Well, it's the stuff that you remember possibly from law school. Those of you who do not practice in this area, how do we avoid piercing of the corporate veil? Well, we showed that there is no commingling between the corporate entity and the individual, meaning that the corporation deposits all of the income into its own bank accounts. None of the income goes into the bank accounts of the individual owners. And the corporation pays only its own expenses and doesn't pay anyone else's expenses. And then we want to make sure that the corporate entity observes all the required corporate formalities, like have meetings and minutes, all the state filing requirements, pay the annual franchise tax, file tax returns. And then the huge one is keeping books and records, having clean books and records. Even when you have legal entities that do pay personal expenses of the individual owners, if the books and records are clean, meaning those payments are reflected as distributions, let's say to shareholders on the corporate books, there will be no commingling. So piercing of the corporate end of the corporate veil is not easy, but the plaintiffs will almost always try it. So let's assume that they can go after the individual assets of our client, either because they pierce the corporate veil or because the client, the individual client, the person, has engaged in infringement himself. And infringement is it's a personal tort, so they can always sue whoever the infringer is, whether it's an individual or a legal entity. Well, so if our client is being sued individually, then we basically need to go through all of the slides that I have in this deck. And I also have, you guys will receive fairly extensive materials on asset protections, about 150 pages worth of substantive materials. Lots of different ways of protecting personal assets, whether it's your residence or your bank account, intellectual property, or what have you. Lots and lots and lots of options that are a little bit beyond the scope of today's presentation. I would just suggest that you keep in mind the basic premise of asset protection, which is to make sure that you do not own your assets in your name. And because anything that you own, whether you are an individual, a natural person, or you are a legal entity, you get sued, whatever assets you own, the plaintiff will take them from you. There are almost no exceptions to that, or some minor exceptions. And if there are assets that are not yours, that you do not own, well, perhaps the plaintiff cannot take those assets from you. So the structures that you will see on the following slides involve planning with irrevocable trusts, planning for a married couple so that we can take community property assets, make them separate property assets, using various legal entities, poison pill provisions, charging order limitations and such to protect assets. And then, of course, using things like, offshore structures. So offshore is very frequently done for intellectual property protection. So we would very frequently set up overseas structures. It can be offshore holding companies, offshore trust, combination of these, to hold our clients' intellectual property portfolios. IP for a lot of large companies, for a lot of our middle market and large cap clients, intellectual property is usually the biggest asset on their balance sheet and the most important one to protect. So we always gonna take extra efforts of protecting IP assets. And because intellectual property is an intangible asset, it is so easy to move it to another jurisdiction. And intangible assets are always governed by the laws of the jurisdiction of where they're located. Meaning that if we have an intangible asset that is owned by someone in California, that is a California asset, and then California laws apply and California collection statutes apply. But if that same intellectual property is owned by, I don't know, a Belize corporation, then now Belize law applies because it's deemed to be a Belize asset. So that makes it a lot more difficult for the plaintiff to collect, because now they're trying to collect on an asset that's outside of the United States that a U.S. judge may not have jurisdiction over. They're subject to foreign laws and foreign collection statutes, and that becomes just extremely difficult and extremely expensive, and very, very difficult for plaintiffs to do this successfully. So that concludes our hour. We both, Scott and I, have tried to get through a lot of material today in the limited time that we had together. Let me just, in the time remaining, answer one or two of the questions that have come up in the Q&A. Does a parent-subsidiary structure work? Would a parent become liable for the actions of a subsidiary for certain types of actions? So the answer is sometimes yes. Sometimes a parent, a corporate entity, may become liable for the obligations of a subsidiary. That is not always the case, but there are certain legal theories, like the theory of substantive aggregation, which you often will see in the context of bankruptcy, piercing of the corporate veil, or just sometimes on equitable grounds. The judge may decide that the parent entity should be liable for the obligations of the subsidiary. And that's obviously relevant not only in the context of copyright infringement, but in every context. Another question, that were an independent contractor is later determined to have actually been an employee, does the employee's former infringement actions incur liability for the employer? And the answer probably is yes. Once someone is deemed to be an employee, it's a retroactive classification. It's not a going forward classification, meaning you've been misclassifying. This person has always been your employee, which means that you are always responsible for their deeds or misdeeds. And then final question, some say that asset protection just does not work, period. What is your response? Well, I have completed over 3,000 asset protection transactions. And I will tell you that it absolutely does work. Now, perhaps different people have different meaning as to what asset protection means. Perhaps some people think that asset protection means that we are making a claim that the assets are protected in a bulletproof manner, that they're just unreachable. And we do not make that claim. It is very rare that we can tell our client that your assets are entirely unreachable. There are some structures like that, but they're fairly rare. Most of the time, what we are able to do is make the client's assets a lot more difficult and a lot more expensive to get at. And our statistics from the 3,000 or so transactions we have handled is that when a plaintiff is confronted with an asset protection structure, in about 30% of cases, they just choose to walk away. And in the remaining cases, 98% of the time, they will settle with our client. And in about 1 to 2% of cases, they will try to penetrate the asset protection structures, argue that they do not work, and sometimes successfully and sometimes unsuccessfully. Scott, here's a question for you. Have attorneys been held to have violated copyright laws when they essentially copy another attorney's complaint?
So the complaint there would enter into the public domain. The issue is largely with forms and contracts. So, I mean, theoretically, yes, I guess a complaint could be found to be infringement, unlikely because it goes in the public domain and the facts are more specific, but contracts contracts and legal documents can be infringing. Once again, you get into the idea dichotomy where ideas are not protected, but if you copy it like an entire form or the words exactly, you might be found to be infringement. But usually, oftentimes, there's only one way to say things or a few ways to say things, so there would not be infringement. And also, there was a computer one about reverse engineering. One thing, very, very quickly, is computer programs receive very thin protection because they're functional. Video games receive more, so the basically how a program works, what it does is not copyrightable. And there was the Lotus 1-2-3 case where that's the old spreadsheet program, and the defendant copied the entire bars structure, the command structure, and it was found not to be infringing.
Thank you, Scott. I think we have one more question. If we move assets to different entities, one that constitute a fraudulent transfer, and do we have concerns about the application of fraudulent transfer laws once a claim has arisen? Yes, we're always concerned with fraudulent transfer laws when we are acting after the fact, meaning there's already a claim against our client. It doesn't have to be a claim that's being litigated, just simply a cause of action, right? The lawsuit can be filed whenever. It doesn't mean that we do not do what we do to protect assets. It just means that the likelihood of success may be less. But there are a lot of different structures that work even when we act at the last minute, when we act after the fact, just because of the practical difficulties that certain structures create of getting at the assets, right? The fraudulent transfer simply means that the transfer is voidable. The plaintiff can now go after the transferred assets. But let's say if the transferred assets are now overseas, does that really do you any good? So obviously we'll try to structure what we do so that it would not be classified as a fraudulent transfer. But for our clients, often it is just irrelevant. If you're going to lose a significant amount of your assets, or perhaps everything that you have, why not try to protect it? The worst that can happen is it's still not going to work, right? So folks, there are some other questions. Perhaps I will answer them privately because I would like to let the rest of you go. Thank you all so much for listening. We appreciate it. Again, this presentation is available on the AlliantLaw.com website and on YouTube, and as well as our prior presentations. So you can go through all the prior webcasts we have done. We have more webcasts coming up every month on different topics, and you're always welcome to join us. I'm Jacob Stein, and with me is Scott Lesowitz, and we thank you so much for participating. Have a great day.